Hello everybody, it's Rick. It's Thursday evening, March 9th, 2017. If you need to reach me, it's Rick0327 at me.com. Alright, I gotta straighten out a couple of things, but I'm showing you here something. One of my subscribers sent the clerk paperwork, as you see here, to the Kings County Clerk's office, which is Brooklyn, New York. Okay, please be advised that Kings County Clerk's office is a recorder of judgments, not a reporter of judgments. Okay. Judgments entered in Kings County are recorded by the Kings County Clerk as mandated under New York Civil Practice Law Rules. That's 5016. Judgments, however, are not reported by the Kings County Clerk office to anyone. So what that means is that if it's recorded with them, in order for anybody to enter a lien against you for, let's say, like New York State is claiming to be a creditor because my friend here, who was nice enough to share this, his ex is claiming well, first of all, she's supposed to have assigned her support rights over to New York State, which would make New York State the creditor. Okay? And then what they do is, then they hand it over to the tax and finance people. All right? But again, all of this has to work with a due process. It has to work with a judgment signed by a judge, signed by a clerk, entered with the clerk's office. Okay, but guess what happened here? What we got here, and I apologize, it's a poor copy, but it's light. Hopefully it'll show up in the recording. If a judgment is mistakenly reported to a credit agency having been entered against a particular person or entity, this is an error in reporting made by the credit or the crediting agent. In other words, it's showing up on his credit that he owes child support, but there's no judgment filed with the clerk's office, which is why we're doing this. All right, people, why am I having you send this to the clerk's office right away? Because we need to see if a judgment is entered against you. And now, if it isn't, they violated due process. And there's a reason for it, because the judgment is void. See how simple this is? It's very simple. I'm following a simple plan. Okay, now look what we got here. I regret, let me see. Let me use one of my nice little tools here. Hold on. Okay. We regret, look at that, I'm doing it sloppy. But anyway, what it says there, let me undo that. What it says there is, I regret any inconvenience you have experienced, and I would suggest you contact the appropriate creditor or crediting reporting agency directly. You know who else you can report? Your employer. Okay? So my friend here could take this and take it and send it to his employer and said, oh, by the way, you know that judgment that you've been taking, that big chunk of my check? Well, there is no judgment. Okay? You don't see the clerk's office apologize too often, okay? Because he got them. And I got mine. Kings County, Queens County, they're right next to each other. I would be surprised if they know about me by now. And they probably have some memo written about what I'm doing. All right, now, here, my friend here, see what we have here? We have a Department of, New York State Department of Tax job. This is a lien, right? He's a lien. But see, you can't have a lien without a judgment. Okay? You see the slickness there? So what they did is they totally bypassed due process. They sent up a fake order that was never recorded, and then they go and they enter the lien in the lien book. See the lien book right there? Judgment, docket, and lien book summary. Now, with me, it said nothing. Most people, but what they did, they were slick. They put the lien in there, but there's no judgment. You can't have one without the other. Okay? So this is proof why you got to do what I'm telling you, to send it to the clerk's office right away. All right, let me get rid of that. So what else I want to talk to you about is that people, they're going to these, they're dealing with these child support people or whoever, and they'll say to them, well, we can do this because of paternity. Okay? No, They can't do this to you because of paternity, because there's a lot of other things I have to consider. Paternity doesn't mean that you automatically owe a debt. All right. Remember, we're sending out documents to validate the debt as well. Okay, and these child support agencies are not cooperating because they can't validate a debt, because a debt is created out of thin air. So what they do is they use paternity, and paternity establishes that you may be the father. Okay, just because you're the father does not mean you have to pay child support. Okay, and let's say you do, you are still entitled to a trial by jury. All right, a guy today in Pennsylvania, right here. Now this is a weak attempt at a court order. All right, order of court. Whereas the court has determined that Franklin County domestic relations. Now you know what they told him. He brought up in court today that he's entitled to a trial by jury. So you know what they said to him? They go, yeah, but our domestic relations law doesn't provide for trial by juries. So, guess what? It doesn't work that way, guys. It works the other way around. The Constitution trumps everything. The Bill of Rights. The Bill of Rights says you're entitled to a trial by jury of any controversy of $20 or more. It's the Seventh Amendment. The Fifth Amendment guarantees your due process, and the 14th Amendment guarantees that right here, Franklin County domestic relations. So any Pennsylvania domestic relations laws that says, well, our domestic relations laws, our process says we don't have to have a trial by jury. Guess what? The 14th Amendment says, no, I don't think so. Your state laws cannot deprive a citizen, American citizen. You always call yourself an American citizen, okay, or a man or a woman, and you're afforded a trial by jury. That's the way it works. But see, they think that their laws trump, the Constitution when it doesn't. All right. The same guy here, Eric, was in court today. He did good. The judge was a jerk. Now listen to the ploy they pulled. He filed this. I banged this out for him yesterday. All right. It's an objection, demand clarification. So that last thing here, right here, he come on, computer. This where the hell is it? The judge here just dismissed it, right? Pursuant, the support conference matter shall be postponed. It is ordered that the defendant's motion for discovery is hereby denied. How can you cannot deny a motion for discovery? All right, this judge is out of control. You have every right to see the evidence against you. However, a hearing of a motion to dismiss, which was today, on the application of paternity, that's a complete oxymoron. All right, the motion to dismiss was based on due process. So anyway, he went there today, and the judge was rude. He told me that the another judge. Now this was a tactic played out with Mike Gilligan in his case. What happened? It happened to me in federal court. What happens is these judges don't want to answer anything directly, so they pawn it off on another judge, which is bullshit. It's hearsay. It's a ploy. And what happened with Mike Gilligan was they pointed off another judge, and then that judge recused himself. So I would be shocked if this judge Myers, Mr. Myers, would recuse himself. And he said that he got irritated with the Writ of Quo Warranto right here, because they don't like having their authority challenged. They don't like somebody calling bullshit on their bullshit. Okay, so what we did here was, all right. Now this is what everybody who has my paper, you have this already. So don't everybody, hey Rick, can you get one for me? No, this is his. Okay. This is an objection to an opinion rendered by Sean D. Myers. By the way, that's what it says right here. Okay, where is it? Come on. Thing. Where the hell does it say? It says it over here. On a second. Hang in there. Well, anyway, it was what the hell is it? Whatever. It was The judge said it was his. I must have when I transferred it over to PDF from the original, it must have got left out. But what it says, it was the opinion of the court. Okay, the opinions of the court has to be based on evidence. Got to be to see the evidence. It should say the evidence presented before the court shows blah blah blah. See, opinions are like an asshole. Everybody has one. All right. We don't want opinions. Okay. We want facts. We want evidence. Okay. So this is the writ of quo warranto, right? Objection, demand clarification. Okay. This is an objection to the opinion rendered by Sean D. Myers. That's the judge. But you know what? He's not acting like a judge. So if he's not acting like a judge, I'm not going to call him judge. Mr. Myers' opinions were not corroborated with facts or evidence, which is in fact an opinion, except one of the people. Call yourself one of the people from now on. All right? Let's stay away from man or woman with the semicolon because of the, the lawless one with the ADL I showed you. What we're trying to do is we're trying to stay away from time-consuming distractions. All right? We're trying to cut through all that stuff because that could take away days and weeks. We don't want to, and we don't want to get into arguments or anything else. All right? Okay. Not corroborated with evidence, which is in fact an opinion, except one of the people, Eric Harris, is guaranteed due process of law and impartial and unbiased equal protection of the law under the 14th Amendment. The intention of this objection, Mr. Myers, is for you to provide clarification, evidence, and jurisdiction to make an order for non-payment of support. Now, here's where I go into, please be advised that any referrals to the United States Constitution or use of semicolons before name cannot be used to discriminate or label one of the people, Eric Harris, a constitutionalist or sovereign citizen, as if he or she is a criminal or any presumptive term associated with any internet movement or cult mentioned in ADL's lawless ones. It is a sad time in our history that one of the people would be presumptively labeled a derogative term for citing his or her guarantees in the United States Constitution, Bill of Rights to protect against deprivations of rights without due process, as in this matter. All right? And this was given in. Very well done. I don't have the time to go through everything. A writ of prohibition, because I'm running out of time. But right here, Harris, the common law writ of quo warranto and writ of prohibition is presented as a demand to view evidence authorizing authority of the judge's name. Now, but meanwhile, he didn't want to show it. The other judge took over it. Okay? So, and here I cite the 7th Amendment and the 14th Amendment. All right? So, we're making progress here. I just showed you that we got a clerk's office. They didn't have the judgment, and they're apologizing. Okay? What we're doing is we're gathering evidence. Now, remember, it's not paternity that says you have to pay child support. You have to have a trial by jury. You have to be afforded due process. Remember that. That's something you have to remember. See, he was in court today, Mr. Harris, and he was able to hold his own. Okay? I cannot hold your hands, guys. I can't fight your battles through emails. You have to learn this stuff. Okay? You're dealing with crooks. We're dealing with people that have an agenda. All these judges, their pensions are paid by this stuff. Okay? Judges make a lot of money. They have very nice pensions, and it's because of this money deposited in from the federal government. So they have a pecuniary interest. And he brought that up today. And the judge, is a wise guy. He's like, well, that writ of quo warranto, I'm not going to answer that because it was humorous. But meanwhile, he didn't answer. It was the other judge that answered it. But he didn't say why it was humorous, because I use very simple words. It wasn't humorous. It was humorous to him because he didn't expect Mr. Harris, Eric Harris, to walk in there and hold his own. Okay? All right, so listen. We're making progress. And if anybody needs the paperwork to get the ball rolling, reach out to rick0327@me.com. Okay? Have a good night, everybody.